A hearing for the Judiciary Non-Civil Committee of the Georgia House. We have two bills on the agenda, both of which are going to be hearing only. As we get toward the crossover deadline of day 30, we sometimes use the full committee as a de facto subcommittee where we can hear a bill, vet out any issues, have some Q&A. We do, if we're able to, if time allows us to have public testimony. We have something of a hard stop around 4 o'clock, maybe 4:15. So what we're going to do is dedicate 45 minutes to Mrs. Cooper's bill, House Bill 965. I see a lot of people signed up for it. I could call on each person to testify for a minute after Mrs. Cooper goes through her bill. We ask questions. I know Mr. Spehouse with the Prosecuting Attorney's Council is here for support and for help on the bill, and I appreciate all of his help. I know for Mrs. Cooper's bill as well as all of our own, frankly, that come through here. I know people have come here to say something. To the extent that we can, we will, but we do have another piece of legislation to get to before, and I know we have others that have got to get out of here by 4 o'clock, and we might be able to stretch that a few minutes. So what I'd ask you to do, ask the author to do, is to be as expeditious as possible. I'm not saying you have to talk a mile a minute, but we'll just need to be conscious of the time. I'll try to get us on track if we get off track, and I'll just turn the floor over to the author.
Thank you, Mr. Chairman. And to the committee, I appreciate the hearing the bill, and to Mr. Spehouse for helping us move this bill forward and being here to answer the legal questions, since I'm not a lawyer. We have a real problem in this country, and one that as legislators we've helped create. As we have made it harder for people to get opiates, there has been an increased amount of heroin coming into our state. When we closed down the pill mills and with the new registry, and that's a good thing, but the drug lords saw a means of getting more money, and they're now bringing heroin in. Heroin is cheaper. A person can get high on a $10 amount of heroin, and it's more deadly. Deadly because there's no control on the concentration, you don't know what it's laced with, and there's just a myriad degree of problems with heroin. And because of that, we are seeing more overdoses in young people mainly between 18 and 29. And because other young people that were with them are afraid of prosecution. So often what happens is when a young person overdoses and is near death, then the young people that are with them, or there are other people taking drugs, they abandon them to let them die. And we have family members here that have had this horrible experience. So what this bill does and what it's like is a bill that we passed a few years ago where we gave amnesty to mothers who wanted to abandon their babies or give them away. And we said, if you just won't put them in a dumpster and let them die, or put them out in the cold and let them die, then if you will take them to a safe harbor, we will give you amnesty and you will not be prosecuted. So what this bill does is it basically says, without going over it line by line, that if you are a young person and you need to call and you're having a severe medical emergency, or you're with someone because of a drug overdose, and you call 911 and you stay with that person till help arrives, then you will not be prosecuted if you've been doing drugs yourself, and neither will the young person. Mr. Spehouse has helped us right into this, where we are not dealing with drug dealers. They can't use this drug to get out of being charged, or anyone else that is already under investigation for other types of offenses. And so I really appreciate the prosecuting attorneys helping me tie it up. But that, in a nutshell, is what the bill does, and we'll be glad to answer questions.
Let me ask the authors as well as Mr. Spehouse what we're looking at, the members of the committee, we're looking at the substitute LC 335546S. 5546S. Between the bill as introduced and now the substitute that we're looking at, there's obviously been some tightening. Can you summarize what the changes are? Maybe not completely. I know some of them are going to be structural and stylistic and so forth, but from a purely substantive basis, can you let us know what direct us to the changes and what the motivation was.
Yeah, thank you, Mr. Chairman. Let me start out by saying that this bill is not brought or necessarily supported by the District Attorneys Association or the Solicitor General's Association, but we as council have been glad to work with Representative Cooper in tailoring this bill in such a fashion that I do believe that fundamentally we support the concepts behind it and are confident that the current version does not pose a barrier to prosecuting cases that were outside the scope of what the author's intent was. So I say that as a caveat, and then let me go in and tell you what suggested changes we've made, why we said that, why we did that, and show you where that's been accomplished. Starting out with Section 3, which is the substantive portion of the bill, and in your substitute, a couple of things that were done. Number one, which starts at line 42, is a drug overdose. One of the couple of things in there that we did to narrow the description was to make clear that the overdose had to be directly tied to the individuals that we were discussing. In other words, either the person calling on behalf of another individual or the individual calling on behalf of theirself. We did that by adding some language at line 47, by the distressed individual. That's language that's been inserted based on some of our conversations and recommendations. Another change in number one is about the reasonable person standard. If you look at line 45, the language, or that a reasonable person would believe to be resulting from the consumption, that language has been changed from the original language, which was a layperson would believe. So we just picked up language consistent with other code sections that set up an objective, reasonable person standard to move into that. Felt like that was more consistent with what both the author was trying to accomplish and that we believe would be consistent with it. A couple of other changes were not necessarily styles, but some cross-references that we believed were needed to be changed. At line 54, we made the clarification that what that code section is trying to do it be, or that portion of it, is to get to possession of less than an ounce of marijuana. It originally cited 1613.2, which of course is the sentencing provision, but 1613.2 doesn't prohibit behavior. It's simply where you go for punishment of less than an ounce of marijuana, similar to theft statutes that outline theft, but you go to the back of theft to figure out how to sentence. So we clarified that by inserting paragraph 1, Section J on line 54 of 1613.30. Another insertion was on line 61. This medical assistance that starts at 58 was designed specifically for a paragraph that's going to talk about the actual seeking of medical assistance, and we inserted the word at line 61, medical, in between emergency and services. There was some concern that a simple outcry to a law enforcement officer might be included in that, and that wasn't the intent. Another substantive change starting at line 63 on seeks medical assistance. If we read that, and perhaps I'll just read it right quick, seeks medical assistance means assessing or assisting in assessing the 911 system, or otherwise contacts or assist in contacting law enforcement or a poison control center, and provides care to a person experiencing or believed to be experiencing a drug overdose, or while waiting on the arrival of a medical assistance. That's the portion where the reporting and staying with an individual till law enforcement gets there is the person that this bill tries to protect, and that we believe the way that has been clarified, that it does simply that. It says if you seek that medical attention, you stay with them, you participated in or possessed the drugs, the policy statement is you shouldn't be charged. If you could have ran and left and avoided prosecution, but you stayed, you did the right thing, you're not going to be charged. We think that that's been narrowed down enough that it accomplishes that. Two more things that were changes in paragraph B that starts at 67. We narrowed that down. For instance, on line 70, we inserted the provision resulted solely from seeking the medical assistance. The concern about the way it was originally worded was, had there been an ongoing investigation of that subject or at that location, and there was independent evidence of a different crime or a different possession or something of that nature, that wasn't what we were trying to protect. We were trying to protect what had gone on right now solely from this 911 call or otherwise seeking medical attention. So that was narrowed up. And finally, in what would have been at line 80, there was originally a provision in there that related to asset forfeiture, and that has been taken out of there. It was our position that with the amendments and changes and all the work that's been done in House Bill 1, for instance, that the precautions and the additions that have gone into that would protect what they're trying to do. I mean, you can't seize somebody's car just for simple usage of drugs, and that was outside the scope of where this was. So those are the substantive changes of this. I believe that this to be a well-worded, well-aimed bill about policy of not prosecuting these cases. The only other thing of substance that's been removed is the original Section 4 related to alcohol has been removed. When you start talking about alcohol, you get into all kinds of concepts and cases that we believe were going to make this more problematic, including the server of the underaged, the individuals that were providing alcohol to underage, that kind of thing. And unfortunately, the way it was worded, we believe we would have been creating a safe haven for that kind of behavior. It's outside the scope of the crutch of what the author's trying to get to. And quite frankly, it took a lot of complicated issues off the table and allowed us to concentrate on this policy statement of this piece of legislation, and it's about drug overdose and the deaths related from drugs, and that's where we're at.
Mr. Chairman, if I could add,
Sure.
There are 14 states that have passed similar laws, so we are not the first. And there are as many that are now looking at the law. I think surrounding us is Florida and South Carolina. So as we put this together, we tried to look at the best practices in their laws. And the statistics they have so far is that it's making a difference. And I will tell you, in the last 3 weeks, or a month at the most, I've read in the paper about 2 young men at UGA that have been found dead in their rooms. And it makes me wonder, I know I'm old, but I don't think dorm life has changed that much with the comings and goings and always having young people around. It makes me wonder if they were doing drugs and they were abandoned when they might have been helped. I don't know that, but it's pretty unusual for 2 young people of college age to die from other circumstances.
It's a fair question to ask. I mean, it doesn't strain credulity to wonder that at all. Questions for the author, for Mr. Spejas, members of the committee? Seeing none, is there anyone, any organization or individual who is here to testify in opposition to House Bill 965, either the original or the substitute? Going once. Okay. Okay. Ms. Ballinger.
I do have a question. Either one of you can answer. Whenever it says shall not be arrested, charged, or prosecuted for a drug violation, how does that line get drawn for law enforcement? As far as questioning, as far as prosecution, where does that line get drawn?
What the line's actually been
because it's not prohibiting investigation. So if they go to their house and they find a big cache of cocaine, where is that line?
That line is drawn by starting at line 48. When we use drug violation in this code section, we're talking about violations of A, which is the possession under 161330. Possession with intent, distribution, all of that falls under B. And keep in mind that trafficking falls under a different code section. So A, a violation of subsection A, 161330 for possession, and we've gone to a weight-based prosecution in drugs. This is the smallest level of felony prosecution. It's possession of a controlled substance in aggregate weight, including mixture, in less than 4 grams of a solid substance, or less than 1 milliliter of a liquid substance, or if the substance has been placed in a second medium, that's like crack cocaine or something of that nature, the combined weight of less than 4 grams. That's the first provision. So it's simple possession of felony drugs, and then B is possession of less than an ounce of marijuana, and then C is 161332.2, which is the possession and use of drug-related objects. So that's the only 3 areas that this law applies to, it's very specific to the concepts of simple possession. And there is an interesting, just to point out to you too, there's nothing, I'll give you line 48, nothing in this code section shall be construed to limit any seizure of evidence or contraband otherwise permitted by law. Nothing herein shall be construed to limit or abridge the authority of a law enforcement officer to detain or to take into custody a person in the course of an investigation or to effect an arrest. So basically, it gives, even if law enforcement makes an arrest, they're probably not going to be liable for it, but it just says we're not going to prosecute that individual for it at a later point. So I think that protects law enforcement when they're sitting there trying to make that decision. But it makes crystal clear to the prosecutor that the case won't get prosecuted.
Okay.
Mrs. Cooper, thank you. You're certainly welcome to stay. As you know, this is hearing only. This is so we can get some public feedback and input on the bill. Barring any unforeseen circumstance, I anticipate we'd go ahead and put it on an agenda for a move tomorrow.
Okay. Thank you, Mr. Chairman. I will stay with
Okay.
families that have come. It's a very emotional and hard time for them, and I appreciate the fact that they're willing to come. Thank you.
Thank you.
Thank you, Mr. Spatos.
Let me call on Dawn Randolph of the Georgia Council on Substance Abuse.
Thank you, Mr. Chairman. You went backwards. I appreciate you. I'm Dawn Randolph, and I represent the Georgia Council on Substance Abuse.
Let me ask you,
Yeah.
if we could, just because our time is tight, if you could limit your comments to just maybe 1 or 2 minutes tops. Because
Less
you
than
heard
that.
what the procedural intention is here. We're
Absolutely.
moving forward.
Absolutely. What we just notice in our work, and the council's been around for 14 years now. I was one of the founding officers of the council. What we have seen is accidental overdose deaths are now the leading cause of accidental death in the United States, exceeding even motor vehicle accidents among people between the ages of 25 and 64. Many of these deaths are preventable if emergency medical assistance is summoned, but people using drug, and we also think alcohol, illegally often fear arrest if they call 911, even in cases where they need emergency medical assistance for a friend or family member at the scene of a suspected overdose. The best way to encourage overdose witnesses to seek medical help is to exempt them from arrest and prosecution for minor drug and alcohol-related violations, an approach we often call the Good Samaritan laws or the 911 Good Samaritan. It's an important step in combating the epidemic of drug overdoses in Georgia. We recognize this is about saving lives and giving people a second chance to get into treatment and engage in recovery supports. With overdose fatalities becoming an increasing problem in Georgia, this law is a good step toward curbing preventable deaths and saving the lives of our loved ones. Therefore, the Georgia Council on Substance Abuse supports House Bill 965. We also want to say that we need to go a step further in looking at referring folks into treatment and prevention as we go down the road. This is a great, great emergency step, but let's look at treatment, let's look at long-term recovery so that we don't have this happening to the next generation. We appreciate the chairman's time and everybody on the committee and hope that if you need any further information about anything involving substance use disorders or addiction, please let us know. Thank you, Chairman.
Thank you. Lieutenant Tanya Smith.
Good afternoon. I got into law enforcement 20 years ago. I got in to make an impact into people's lives, to save a life. Last year I lost my daughter to this, to drug overdose. So the one life that I wanted to impact more than anything, I couldn't. She died simply because the people that she was with were too afraid to call 911. They didn't know what to do, so they let her die. And they went a step further and discarded her body on the side of a road to conceal their involvement, to avoid arrest. I know that if this law was in effect, she would be alive. And as an officer, and in speaking with the countless officers that I know over my 20-year career, they would be relieved that this law was in place, because that's not what we want to do. We're not interested in arrest in an emergency situation when a life is on the line. We don't want that. I don't want that. And the 4 people involved in my daughter's death were indicted on Monday. I could care less. It doesn't bring her back. I don't care that they're facing a drug charge. She's not here. She's in an urn on my mantle. And if there's a parent out there that this law avoids that for, I'm sorry.
It's all right.
I would hate for another parent to have to go through this. And as a law enforcement officer, I don't want to watch it ever again. I've seen it too much. So I know that this bill has the support of the law enforcement community. It has the support of all the officers that I've spoke with, and I wholeheartedly stand behind it.
Thank you very much. Just so, are there any other members of law enforcement who are here specifically on House Bill 965? Mr. Rotundo, did you want to speak to it?
Yes, sir. I have a little bit more time in law enforcement than Ms. Smith has. It's 45 years, and I just wish the state that I originally came from was proactive in this fashion or reactive to other states' changes first. This is certainly a very plus, and as Lieutenant Smith said, the objective of law enforcement is to protect and to serve and to protect lives, and this bill certainly helps protect lives. And thank you for the consideration.
Well, not to me. The thanks goes to Representative Cooper. And the organization you represent.
I'm the executive director of the Georgia Association of Chiefs of Police, and I think I'm very affected by Lieutenant Tanya Smith's plight, which occurred probably about 6 months ago, and she works very closely with our association as a certification manager for that department that she works
And I'm presuming your association endorses the bill.
I would say I haven't gotten fully the substitute before the association, but the reality is I asked the prosecuting attorney's council to look at the concerns that I had. Mm-hmm. I said there were some concerns. They looked at them, and it appears that it's properly vetted at this point in time, that I would say that if brought before my total association, there'd be no problem endorsing it.
Okay. Good to know.
Thank you.
Thank you, Mr. Rotundo. Mr. Justin Leaf with Georgia, is it Georgia OD Prevention? Is that the name?
That's right. That's correct.
Okay. Mr. Leaf, if you could confine yourself just a minute
Thank you
or
for
two.
coming today. My name is Justin Leaf, and I'm 24 years old. I'm a law student. I was a legislative intern and aide here at the Georgia General Assembly. 1 year was with Madam Chair Cooper, and I'm here because I lost 6 friends to overdose deaths since graduating high school, one of which was my best childhood friend, Zachary Elliott. I believe in the legislative process, and I hope that we can get this passed. I know too often my job was easy because we were 45th to do something, and I could look to other states, and for once I'd like for us to be at the top of the heap relatively to do something like this. So I thank you for your time, and I ask that you listen to the people behind me. Thank you.
Thank you. I can tell you when a bill that goes in with a late number, it'll pass for 2 reasons. Number 1 is the strength of the idea, and number 2 is the will of the author in that order. And it seems to me that this bill's got both of those things going for it. Robin and Stan, is it Cardigas? Cardigas. And again, I apologize to you both. If you could confine your comments to about a minute or 2, we'd appreciate it. Thank you.
First of all, I'd like to tell you thank you for having us and listening to us. Thank you, members of the committee. And we'll keep it brief. I'd like you to know our son, Stephen Cardigas, who on August the 12th, 2012, made the deeply regrettable choice to try heroin. He was in a vehicle with a driver and other passengers who drove around with his body as he was suffering respiratory failure because they were afraid to take him to the hospital. They were afraid to call 911 because they were afraid they would be arrested. When they finally did end up at the home of someone with enough sense to call 911, the first responders took him to the hospital where he was dead on arrival. The other occupants of the vehicle said that their actions were for fear of prosecution. They were arrested. They were prosecuted. And if we can it's hard to tell his story. It's very difficult. But if we can save one other family from going through this terrible, terrible tragedy, we're willing to do it.
My son was a good kid. He was 20 years old, 9 days from becoming 21. He was trying to get in the military. He did stupid things with stupid friends that and you'll hear from other people, that when you've got a 20-year-old, he's still a boy in my mind, but he's a man. He went out and did something. We had no idea, first of all, that he was involved in heroin. We knew about marijuana. It's everywhere. It's in school. Even our president's talking about marijuana, which is just mind-blowing to me. And I'm really upset just even that, because it's a gateway drug. But he's a good kid, Eagle Scout. He didn't deserve to die in the back seat of a car with a mile and a half from East Side Medical Center. And if they'd had the comments, because it was in the police report, they were afraid to call for help. They were stupid kids too. And that's really who most of these people are, young people. You're not seeing too many older people like me and my wife ODing on heroin. I wouldn't know where to find it, but it's everywhere. And you're going to see it more and more in the whole country. So anything you guys can do, we'd appreciate. I mean, it's just common sense.
Thank you very
For
much.
the love of God, and we're sorry about your daughter.
We call Diane and Rose Brannon. And again, the same time admonition. Please. I hate saying that every time, but I have to, just for purposes of keeping the meeting going. Thank you for your understanding.
My name's Diane Brannon. This is a picture of my husband, Randy, daughter, Rose, who's standing to the right, myself, and my son, Randall Brannon. We're just like any other family. We're a happy family of four. This was taken on a beautiful spring day. Shortly after this picture was taken, my son attended an Eagle Scout ceremony. He was a lifetime member of the Boy Scouts of America. We had many happy weekends camping as a family with his troop. Our son Randall had many interests and talents. Among them, he was an avid auto enthusiast, guitarist, skeet shooter, chess player, competitive swimmer, soccer, baseball player, and he enjoyed boating and archery. He was a very talented and loving young man. He was a dutiful son and a loving brother. Oh, your turn.
In March 2013, he went to a spring break party in McDonough. He had a few drinks, and in the company of a few friends, he decided to experiment with a designer hallucinogen. Soon after taking it, he started to show very dramatic, clear signs of a life-threatening overdose. He began to feel overheated, his heart started pounding, and then he fell on the ground and started seizing for several minutes. There was a long period of time from when he started showing signs of an overdose to when he died. There was a hospital less than 1.5 miles away from his party. My brother never made it to the hospital because his friends feared calling 911. A couple of his friends had just gotten off probation, and they did not want to get sent back to jail for giving him a few beers 9 months before his 21st birthday. In those crucial minutes, they had to choose between saving my brother's life and avoiding jail time. They decided to cross his fingers and hope that he pulled through, and he died. His friends panicked and dumped his body on my parents' lawn while my parents were at church the next morning. As soon as my mother returned home and found out what had happened, she called me and told me to come by their house. When I turned into the road by my parents' house, I saw a swarm of cop cars in front of their house, yellow tape blocking off the street, and my parents sitting on the ground holding each other, sobbing. They grabbed me and barely choked out the words to tell me what happened. The last time I saw my little brother, he was blue, stiff, and half covered by a white sheet. Preserving human life is more important than putting one more minor drug user behind bars. When I become a nurse, when I graduate this semester, I want to help little people like my brother, so no other families have to go through the same thing that we've had to go through. Please vote to make Georgia a safe and saner place. Thank you for your time.
Thank you.
Thank you for taking the time to be here. Susan, is it Calumet? That works. So that's not right.
That's really good. That's really good. So I'm Susan Calumet, and my story's not unlike the others that you've already heard. I mean, I lost my son 4.5 years ago. Heroin first started it with Oxy. By the time we found out heroin, because heroin was cheaper. It's tragic for everybody, and it's horrible, but I kind of talked to one of Sean's friends who also went through addiction, and one of the things that you kind of look at, he's recovered from heroin addiction, has a good job, a young family, and he had some great insight, I think, in support of this bill. He said that we need to take every opportunity to educate people about the dangers of this drug. We'll never be able to stop people from using it, but we can do everything possible to save lives. One day this bill could help save the life of your friend, your parent, your brother, or children. Remember that everyone deserves a chance to live, and sometimes it takes a second chance. This drug is lethal enough by itself, but what's even more lethal is the culture surrounding it, including not taking action to save someone's life for fear of personal consequence. There's no greater act than saving the life of a fellow man. So even though a person may be doing the wrong thing with their own life, we can't condemn them for trying to save the lives of another person. The focus of this bill is not from people trying to say that drug use is acceptable. It's simply people who have educated themselves and understand that even though we can't prevent use and we can't save everyone, we can save some. And at the end of the day, that's what really matters. So, thank you.
Thank you. Ms. Robin Elliott.
Hi, good afternoon. My story isn't very different from a lot of the other ones you've heard. My beautiful, bright, talented 21-year-old son died on May 1st, 2011 of a heroin overdose. He went to private school here in Atlanta. He played the electric guitar. He was an athlete and had a very high IQ, came from a loving family, comfortable home, but he used heroin. I think over the last 2 years, he started smoking pot when he was 16 and started using heroin when he was 18. But for the last 2 years of his life, he was more sober than he was using. He was really, really trying to get better, to go into recovery. Unfortunately, he didn't get a second chance, and we'll never know if he was with anyone when he died because his body was found in the backseat of his grandparents' car in the English Avenue neighborhood of Atlanta by some neighborhood kids. He was dead, and he was by himself, and that's pretty much all we know. The one thing I want to say is that many of Zach's friends that he met in rehab, in AA, and people that he used with here in Atlanta now are in long-term recovery. They have between 2.5 and 7 years of recovery. 6 kids that I'm in touch with regularly. 2 have graduated from college, or graduating from college this year, 2 years later than they should have, but they're graduating. 4 of them have married. 2 of those 4 now have babies, and the other 2, their wives are pregnant. And it's because they're alive. And they lived long enough to get into long-term recovery and to overcome their opiate addiction. So my war cry is, if they're alive, there's hope. And like everybody else said, please pass this so that no other mother ever has to feel the way I feel every single day. Thank you.
Thank you. Mr. Paul Barnett.
Hi, I'd like to tell a short story about the short life of my son Robert. He died on his 16th birthday. He started taking drugs at 15 and a half. 6 months later he died. And he was in a room at his mother's home, and we were divorced. I had his birthday party with him that morning. That afternoon he went to her house. They were supposed to go to a Braves game. It rained. Instead, friends came over, and they partied in the bedroom, and 2 of them were 18. One was 19, and he was turning 16 that day. She's a doctor. She was two rooms down from him. As he lay dying, and a second boy, went into a coma. The other two were scared. They climbed out the window and left. With a doctor 100 feet away, Northside Hospital half a mile away. I don't know how we educate them, but if they knew they were not at risk, they might have helped, and they might have saved Robert. He was gifted, like all of them. But he's gone. Thank you.
Thank you. Ms. Lori Fugit.
Hi. I became involved in this effort when I realized I had 7 friends whose children had died from drug overdoses in Georgia, and I had one friend whose son had overdosed and had lived. And the difference between the ones who had perished and the one who lived was the one who lived had friends that called, and they called in time. Half of all overdoses occur in the company of others, but most of the time nobody calls 911 for fear of legal repercussions. The fear of arrest is so strong that it causes what began as a poor choice to mushroom into a tragedy. No one should have to decide between whether to save a friend's life or avoid arrest for controlled substances, especially in situations where every second counts. When someone is minutes between life and death, it is not the time for discussions about personal responsibility and self-induced consequences. It's the time to act. As a society, we do not refuse people defibrillators when they're having a heart attack for poor diet or for smoking. And in the same vein, this bill was created with the premise that lives do not matter less because of drug involvement, and that saving that life is not tantamount to sanctioning and encouraging drug use. Calling 911 for help should never be a crime. The focus in an overdose should be not to punish people, but to keep them safe and bring them back to health. As Detective Gary Martin of the Florida Sheriff's Association states, these medical amnesty laws do not cost anything. They may even save money because fewer people are incarcerated. Every life saved is one less autopsy, one less law enforcement investigation that the state has to pay for. These laws allow us to protect and serve the community better. The 911 medical amnesty bill can be the most life-affirming action that the Georgia legislature takes this year. Georgia should be the next state to pass a 911 medical amnesty law for a safer and healthier Georgia. Thank you very much.
Thank you. Ms. Eccles? Okay. Rachel McGinnis?
Hi, my name is Rachel Moore. My son Malcolm McGinnis died Memorial Day weekend 2011. He'd spent the day with a friend from high school who was home on leave from Afghanistan. When Malcolm passed out, the soldier who had lived through Afghanistan was afraid to call, and he left, and my son died. Shouldn't be afraid to call to save someone's life. And that's all I wanted to say.
Thank you for coming down here. Anita LaMonica, please.
Hello. Thank you. Thank you for having us here and listening. It's my daughter, Marissa LaMonica, and I lost her August of 2012. I'm relatively new to Atlanta, and it's hard to believe that I'm standing here and that all of us are standing here. My daughter had a little boy. She suffered with bipolar from the onset of the age of 12. And she struggled, but she loved this child more than anything, as I loved her. She gave so much of herself to others, but she lost her life. A phone call she made at 5 o'clock in the morning, and nobody heard that call. I want to say it is not just me, it is not just us, it is all of us. We are here in this together, as family, as a community, as a nation. Life is so valuable, so precious. When we save a life, that life can save somebody. in your home, in your family, because there is nothing more important. Nothing at all. Thank you.
Thank you. John Goodfriend.
Thank you, Mr. Chairman, members of the committee. My name is John Goodfriend. I'm not here on behalf of an organization, but I am here on the behalf of my friend who passed away of a drug overdose in high school. He laid there and died. His friends partied around him, and by the time they realized his condition had deteriorated, they were too afraid to call proper medical attention for my friend. And he died the next morning while they all left the house party for his parents to discover his body as he lay there cold. And it really rocked my high school community. This medical amnesty legislation is a great piece of legislation. The author's done a great job. I'm a senior at the University of Georgia. I'm somebody who's been exposed to some situations, even with drug and alcohol, has been introduced to a particular surrounding or an event. And I can say that while the alcohol portion of this legislation has been taken out, hopefully the author will move forward in future sessions so we can get that placed in there, because I do have several friends who have suffered those consequences as well, who have been placed in situations where they have had a friend pass away, or they were the ones that had to decide whether or not to call proper authorities to get their friends some medical attention. And you know, just as a friend, I would wish I had my friend back. He was a dear friend of mine, and if this legislation could have saved his life then, I hope that we can pass it now, so that we can continue to save the lives of young Georgians such as myself, and so that friends like me are no longer placed in situations where, and my peers are placed in situations where we have to choose between the life and the death of a friend, and that we can get them some proper medical attention. I thank the committee for hearing my comments today, and I appreciate it. And I hope you do pass this in the full committee as is. Thank you so much.
Thank you, Mr. Goodfriend. I don't know about other members of the committee, but I can't remember the last time I saw a senior in college come down here and present so well. Good for you.
Thank you.
I think we'll see him again. Not in Smyrna, though. Did I say that out loud? Marshall Rancifer will be our final witness.
And Mr. Chairman, when he finishes, may I have just 1 minute to make a comment?
All right.
It will be very short.
It's fine.
Good afternoon, everyone. My name is Marshall Rancifer. I'm a harm reductionist, and I'm also a community activist. I live and work in the English Avenue neighborhood known as the Bluff. I've witnessed overdoses. I'm a recovering addict also myself, and so I've seen people overdose myself. The Sunday of the Trayvon Martin rally last fall, I was leaving the neighborhood, and two young ladies were across the street at Paynes and Boone, and one young lady was pulling the other lady out of the car because she was overdosing, and I recognized it. And I pulled across had my friends pull across the street and helped her get out of the car, and I asked the lady if she called 911, and she told me no. By that time, Atlanta police officer pulled up and refused to let me render aid to her, and just so happened an ambulance pulled up a few minutes later that had naloxone on board, and they gave her a shot and brought her right back out of the overdose. But I said this to say this: a lot of people lose their lives every year across this country needlessly to overdoses. And if y'all pass this bill, it will stop a lot of unnecessary deaths. I've lost a lot of friends who either relapsed and overdose or just overdosed because they were still using. And this law would save a lot of lives. And I just implore you to please pass this bill.
Thank you for coming down here. The author will have the final word.
Thank you, Mr. Chairman. I want to give credit where credit's due, and it certainly shows that one person can start a change for the good. And Justin Leith, who was my intern, is the one behind this bill, not me. And the parents, so that the committee will know. The parents are committed to getting the word out, just as when mothers set and changed our laws about alcohol and what we do about that and educated young people. They're committed to going into our schools and our colleges to talk about the new law should it pass and educate young people about the problems with heroin, but what they also should do if a friend gets in trouble. So I thank them for that, and I thank them for coming. Thank you, Mr. Chairman.
Yes, ma'am. Thank you for bringing the issue. I anticipate that we'll accept a motion tomorrow, assuming we start relatively on time, about 1:30 or so, and then we'll go from there. I do think that will be an issue that will need to be addressed at some point, and that is that, you know, should this go through the process and be enacted, then there's the issue of publicizing and the education piece that comes along with it. We have all the laws in the books, but if people don't know about it, that'll be a long-term process for sure.
I have explained, Mr. Chairman, explained to the parents that we have no budget or anything else, that once we pass the laws that we have to rely on the agencies like the prosecuting attorneys and all, and that they can do much more in the school system for getting it out than us.
And getting it out in a certain manner.
Yes, sir.
Right. Thank you. All right. We'll, that'll bring to closure our consideration of House Bill 965. We will pivot quickly to House Bill 863, members of the committee. This is an animal strengthening of our existing animal cruelty law that was put in several weeks ago. It's gone through several iterations, and I wouldn't expect members of the committee to have studied very closely the bill as introduced, certainly. But other than the general intent of strengthening our animal cruelty laws, what we had in the previous as introduced version, I think it's important to have the background and the context of it, is that when you take a look at the definition of adequate care and the substitute, that's LC 295912S. We had originally had a laundry list of requirements and actually definitions for adequate care, adequate food, adequate water, adequate ventilation, adequate shelter, and so on. And what that generally did is it made the issue a lot more complicated, to be candid with you, than it really needed to be. It also provided the opportunity for unanticipated, consequences to kick in. You'd have otherwise legal behavior that, because it could be construed as not falling into a particular definition, that otherwise legal behavior and accepted behavior and actions all of a sudden would become criminal. And that's not what the intent of the bill is. The intent of the bill then as now is to go after those bad actors in our society who candidly will maliciously torture, poison innocent animals. We read or saw on the television within the last week, I think, the example of the individual who tossed a dog out the window. It's to address those particular situations. What I was really sensitive to at the beginning and continue to be sensitive to are those actions that and those activities that we have. And of course, we've all heard from sportsmen, from hunters, not just on this issue, but on various issues, that there are certain traditions, there are certain ways that they have of training the animals and so forth, that some people in our society, in our state, wouldn't necessarily identify with. What is custom and practice in Marietta is not necessarily custom and practice in South Georgia. And so when you get into, and more to the point, what would be accepted adequate in terms of food, water, sanitary conditions, whatever it may be. And a lot of that is, I think, for lack of a better term, sometimes, not sometimes, all the time, community standards. How does a particular community view that? My sense of it is, I have absolutely no basis for saying this, but I'm willing to bet $1 on it, that if you went, to Swainsboro, for instance, and asked about, what constitutes adequate water, adequate food, adequate shelter, that may be very different than what some homeowners in the Vinings area of Cobb County may say. And that's okay, and that's okay. So rather than getting into the fly-specking exercise of what actually constitutes within those definitions and getting into a real potential problem in terms of overstepping, we decided ultimately, and I want to just make sure I thank Chuck Spahas and Lelaine Briones from the Prosecuting Attorney's Council for all their help in drafting and redrafting and redrafting, and with the help of several prosecutors who I think we'll hear from in a little bit, to really simplify the measure to get to those individuals that we're really trying to get to, and to get to that conduct that we're really trying to get to, and to not include the conduct that we really don't need to get to because it's not otherwise criminal. Finding that balance is not necessarily an easy task. It's an exercise that I don't recommend to anyone in the legislative process, but it's been an education, and it's been a worthwhile education in all seriousness. So you see the definition of adequate care. You see the definition of malice beginning on line 24. That definition, and the PAC and the prosecutors can speak to it better than I can, but that comes from a pattern jury charge as well as existing case law, and they have the cites if anybody cares to review that. And then we get into the actual offense of cruelty to animals, where we're talking about the situations and the definition of what is cruelty to animals as a misdemeanor, and then we get into it as a felony. Now we have aggravated cruelty to animals. The main thing I want to draw your attention to on line 34, causes physical pain, suffering, or death to an animal by an unjustifiable act or omission. Then we have a clause there that says, other than by the willful, wanton, or reckless failure to provide adequate care to an animal, or having care and control of an animal, willfully, wantonly, or recklessly fails to provide adequate care to such an animal. I think what we're probably going to end up doing is striking the words other than by the willful or wanton or reckless, because all we're doing is when you, in line 34, where you are purposefully, I'll say, causing physical pain, suffering, or death to an animal by any unjustifiable act or omission. Or then skip down to line 37, when you have care and control of an animal, you have a duty at that point to provide adequate care. When you have care and control of an animal, willfully, wantonly, or recklessly failing to provide adequate care to such animal. And again, adequate care is defined in lines 13 to 16. I just think that clause beginning with the word other to the semicolon on line 36 just is confusing, and it's not necessary language. Right. It is something that we don't really need. I just don't think it makes for a smooth read in the statute. Then when we get into aggravated, before that actually, line 45 skipping down to 54, this is where if they've had a prior adjudication within our state or any other state, this is pretty standard language that we've seen in other statutes as well, in order to go ahead and account for a second offense. I'm almost done, but go ahead. Let me just fly through this as best I can, but still be substantive about it, and then we'll have a dialogue after that. Then we get into, again, the definition of, well, actually, the offense of aggravated cruelty to animals, maliciously causing the death, causing physical harm to an animal by depriving it of a member of its body, serious disfigurement, torture beginning on line 64, poisoning beginning on line 66, and then on line 68, having care and control of the animal, the duty to go ahead and render care and control, maliciously failing to provide adequate care to such animal to the extent that the death of such animal results or a member of its body is rendered useless, etc. And that's sort of the checklist of possibilities where someone could be charged for aggravated cruelty to animals and the malice component that goes along with that. I think it's important to recognize the existing language, very important for me to, and of course the sentencing provisions that follow, but the existing language on lines 89 to 97 of the substitute that shall not be construed as prohibiting conduct which is otherwise permitted under the laws of the state. referencing the comments I made earlier, agricultural, animal husbandry, butchering, food processing, etc. We didn't want to overstep and start criminalizing otherwise legal behavior. And again, this is existing law that you see on lines 89 to 97. Had we gone ahead and more definitively defined, going back to the definition of adequate care, had we gone ahead and more definitively defined adequate food, adequate water, sanitary conditions, adequate ventilation, really defining them in terms of the real fly-specking specifics on that, after again getting educated and getting a lot of different feedback, including from some great people at the agriculture department, I came to understand that if we went ahead and did that, we'd actually be stepping on current agriculture regulations, and that would be an even bigger disaster. So again, that led me back on this odyssey to really simplify the bill, go to the heart of the matter in terms of the malicious conduct, what we're seeing in terms of torture, and the animal control officers and the prosecutors can speak to it 10 times better than I can. But the conduct that we're seeking to get into this net, but not getting the conduct that is otherwise legal, that we do not want to go ahead and gather up, certainly. So let me go ahead and answer any questions that members may have. Then I'm going to ask Mr. Spahos and Ms. Briones if they, or whoever would be appropriate, to come forward and speak to the bill if they want to. Or do you just want to lay back as a resource, Mr. Spahos and Ms. Briones?
Defer to you, Mr. Chairman.
Okay, let's just see how it goes. Ms. Bellinger.
I did have a question about the, whenever we're including, I'm on line 49, whenever we're including the adjudication of a juvenile, it's my understanding that usually those records are sealed. And would there be a distinction made between an informal and a formal adjudication? Because it's my understanding that an informal adjudication of a juvenile is something kind of like pretrial diversion, where it kind of...
I'd have to defer to Mr. Spahos or the prosecutors on that.
I'll say this: if there's a withholding of adjudication, even in juvenile court, then you wouldn't have that problem. But 49 to 50 is including an adjudication in juvenile court. So if it was a diversion, I would say no. I think this is only intended to cover an actual...
A formal adjudication as opposed to an informal adjudication?
And this language is in other places in the code where we try to grab all prior convictions. But I think a withholding of adjudication in juvenile court, or quite frankly even in state court, would not fall under this. You would have to be convicted or adjudicated in juvenile court previously for the subsequent act to occur. I mean, for the subsequent punishment to occur. And the misdemeanor, the stepped-up version, is a high and aggravated misdemeanor.
So how would that handle, like, on if there was a formal adjudication in juvenile court? Because it's my understanding that those records are sealed. Because I know I've had conversations with my solicitor, actually, kind of getting wanting access to those records if there's a prior.
I think state law is going to control that, because different states have different rules about adjudication in juvenile court. That's one of the reasons I think this references other states in the United States. Quite frankly, I don't ever remember having used a juvenile court conviction in any misdemeanor prosecution for aggravated punishment, because we didn't have access to the records. I think you would necessarily have to have access to the records. I think this provision says if you can prove it took place in juvenile court, you can use it for the aggravated misdemeanor.
Okay.
Ms. Kendrick.
I just had a question about 108, lines 108 and 109. So in the situation where somebody is breaking into a house and people have guard dogs, and the guard dog attacks the person that's burglarizing the house, they're going to be charged with, under this statute, as well as a robbery charge or a burglary charge. I'm just trying to understand, is that what 108 and 109 mean?
Yeah, I mean, if they're attempting to committing or fleeing after the commission or attempted commission of a felony, in other words, they're at some point in the process of committing a felony, they don't have any justification for killing an animal in that situation. In other words, they're in a robbery
Okay.
Is
I
a-
mean, even this is assuming even if they have a guard dog and the guard dog attacks the robber.
Yeah.
Or,
I think that's exactly what you're intending to get to.
Yeah.
You've got to read 1 and 2 in conjunction with one another. If you start out at 103, 1 is this is the exception of when you can kill an animal, but 2 is you can't apply Section 1 unless, quite frankly, you've got clean hands.
Mm-hmm.
So I think you're right on point. That's if you're doing any of this, then you can't kill the guard dog.
mm-hmm. And a follow-up question, I don't know if anybody knows this. So in the event that the burglar is charged, are they charged, does this lesser crime merge with the
No.
burglary charge, or it'll be two separate charges?
There's additional elements here, so as long as you allege and prove the additional elements, there'd be no reason for merger. This would be like also proving whatever act was committed during the burglary. Maybe there was an aggravated assault. As long as you can prove the aggravated assault, then they don't necessarily merge.
Okay, I see no further questions. I know that there are some prosecutors who have been here, who are here to I think it'd be constructive for the committee to hear from any of the line prosecutors who happen to work on these cases to very briefly give us an idea of what you see. It's one thing for me to sit here and to say we need this bill, for these circumstances, but I don't see this on an everyday basis. But there's some people in this room who do. If those folks would like to come, they don't have to. There's no have tos around here. You don't have to, but I think it might be helpful for the committee to hear just very briefly what it is that you're seeing, and hopefully the bill addresses it or helps to address the situations that you see.
Hi, I'm Allison Cawthon. I'm with the Gwinnett County Solicitor's Office. I wanted to thank you so very much for taking on this important legislation. We do need a change in the law to, clarify and to improve our current animal cruelty laws, because I prosecute misdemeanor cruelty cases, and the majority of these are going to be animal neglect type situations, and it is hard the way the current law is with the willful neglect language in there to conquer and to prosecute some of these bills. And I think the changes that you've made are important, and they're going to do wonders. And I support PAC for working on this, and I appreciate you taking all these changes. I think it's going to make a huge difference in how we prosecute our cruelty, our misdemeanor, as well as our felony cruelty.
We tried to simplify it, and of course sometimes when you try to simplify a bill too much, it renders it useless, and that doesn't matter what subject matter you're talking about. My hope is that we got to a balance point where we're addressing conduct that's out there that's not otherwise being addressed appropriately, but we're not simplifying it so much that it's not going to have the intended effect.
And I think you've done a good job doing that. And I think by striking on line 35 the language after the word other, I think that will make it less confusing, especially for new prosecutors when they take a look at it, to just make it very straightforward.
If there are any other suggestions that your group would have, cosmetic or otherwise, that again, we're in balancing a bill like this and trying not to overstep it. We sometimes get to changes. Well, now we're getting into, now we're getting a little too far. If there are any other suggestions that would just make it a cleaner work product, we'd welcome that.
And I think that's a good point, because our current case law right now is that malice and intent are not elements of misdemeanor cruelty for the act or omission. So I think it's important to know that we do have, many cases that, intent is not an element for misdemeanor cruelty. So having the willfully, wantonly, or recklessly on line 37 prior to the word fails, I think if that was removed, it would, what the case law is if you fail to provide adequate care, or that is the crime. You don't have to have a mens rea before that. It's because the intent is not required. And that's, that's cases we've had 2003, 95, 96. So I think that's important.
All All right, let's continue to discuss that, and maybe we'll huddle with Mr. Spahos and Ms. Briones as well, just to get a meeting of the minds on that.
And good afternoon. My name is Jessica Rock. I am a prosecutor in DeKalb County, and I actually started my career prosecuting misdemeanor animal cruelty cases back in 2003. And I have continued to prosecute not only misdemeanor animal cruelty cases, but also spent 4 years in the DA's office in DeKalb County prosecuting felony animal cruelty cases. I am now back in the solicitor's office in DeKalb County, supervising a unit that prosecutes misdemeanor animal cruelty cases again. And I just wanted to also express my sincere gratitude to you, Representative Gullig, and to Chuck Spahos and everybody else who's worked on this bill. It means a lot to those of us who witness the horrors of what we see people do to animals on a regular basis. Just countless cases of people who are leaving animals locked in closets when they move out of homes and purposely leaving them there with muzzles on and tying their feet together. And just countless cases of people tying animals up in the backyard in the middle of nowhere to leave them to starve to death and to die. Those are the bulk of the cases that we deal with on the cruelty level. Is misdemeanor basically neglect cases. They are by far a large majority of the cruelty cases that we see in the state of Georgia. I would also go ahead and echo Allison's suggestion that we take a closer look at the misdemeanor section. And again, we're only talking about the misdemeanor section, about removing the language willfully, wanton, and recklessly on line 37. I can just specifically point to a couple cases. One is Cox versus the state. It's a 1995 case. And in that case, the court stated that willfulness, malice, and intent are not elements of the offense of cruelty to animals in the second degree. Again, Cotton versus the state, 2003. Malice and intent are not elements of the offense of cruelty to animals with regard to act and omission portions of the statute. So we do think that just simply removing that language in that one line would by far strengthen the bill and honestly address the bulk of what we see the cases being, and that is the failure of people to adequately care for animals, leaving them places just to die and to suffer horrible, horrible deaths of not only starvation, dehydration, but a lot of times in the summertime we see the elements with the weather when it gets so hot, and in the winter months when it gets so cold, animals that are just left to die out in the elements as well.
So just to be clear, what you're recommending is that beginning on line 37, that it would read, having care and control of an animal fails to provide adequate care to such animal.
Yes, and that is currently the way that our law is, as it stands now in the misdemeanor section is.
Okay.
But other than that, we think that this is a great improvement over what we have now, and we are excited about being able to prosecute these horrible acts that we see on a daily basis.
Thank you very much for taking the time to come down here. We know it's a hassle to come down here. You've got other things to do, and we really appreciate it.
And thank you for having us.
Thank you. Mr. Atwood.
I just want to be sure, prosecutors, before you sit down, if you could, on line 37, you suggested removing willfully, wantonly, and recklessly? Is that correct? Did I hear you correctly?
Yes.
Line 37? Okay,
Yes.
I just want to be sure I had that.
Yes.
Thank you.
And we'll chat offline with Mr. Spahos, after the meeting and this evening before a substitute gets drawn.
Okay. Hayward Altman, District Attorney, Middle Judicial Circuit.
Mr. Altman, thank you for being here.
And I appreciate the shout out to Swainsboro. Because Swainsboro is in my circuit, so I appreciate that very much.
You were in the back of my mind.
There you go. I do want to thank you. I want to also say that we, as a district attorney from a rural area, that I would support this particular bill from the standpoint of the definition of adequate care, because as you previously stated, it would allow a community standard, because there is a difference on how someone from a rural circuit such as mine, and mine is truly rural, versus someone how they would look at it in the city. We have bird dogs, we have coon dogs, we have deer dogs. Those hunters have to do certain things to be able to care for their dogs. But I can assure you there's not one legitimate hunter not one bird dog owner, coon dog owner, or deer dog owner that is not offended by someone who doesn't care for their dogs. In fact, they probably care more so than most people do.
And they have a serious investment in those animals as well.
A very serious investment in those animals. So I think they'll be very happy to know that you're actually looking after their interest in doing this, and that this would probably be met with their agreement too. I can't say that for certain, but I'm assuming that most deer hunters and bird dog hunters or bird hunters would be very happy with the word adequate care.
Well, the intent here, and I think more importantly, not just the intent, but the wording, recognizes the fact that I often give the example. I have a friend of mine in my Rotary Club in Vinings, my former Rotary Club. I'm an honorary member because all of my time down here ruined the attendance rating of the club, so they eased me into honorary status very deftly.
They just kicked me out.
He was a...
Well, you can come to Swain, I'm president of Exchange Club.
Thank you. He was he did the Iditarod race.
Right. I know all about it.
And those dogs, those dogs are different.
Yes.
They're instinctually different. They're different from the dogs in Swainsboro, the hunting dogs, the bird dogs, the dogs that do the field trials. We understand that. And different from my fairly, well, I'll say, lackadaisical black lab in the Smyrna Vinings area of Cobb County. But those are all very different standards. And if you ask a jury, more importantly, in Nome, Alaska,
sure,
or in Swainsboro, or in Marietta, that's going to be a different. And I know community standard is not the legal term of art, but we know what we're talking about. Sure. It's what they believe it is, because ultimately it's a reasonableness test. With that kind of just Webster's dictionary definition of adequate care.
Yeah. And I thank you for that, because it shows you appreciate the people in those particular areas versus just setting a standard that would be objectable to them, that you're actually taking consideration the thoughts and feelings of people in those areas. One other thing, you asked for examples. It would have been nice to have this whenever I had this elderly lady and her son who were taking care of horses. Mm-hmm. They had them in South Carolina and in Jefferson County, Louisville, Georgia, which is also on my circuit. They basically let the horses starve to death. Thankfully, we were able to prosecute them and send them to prison on a bunch of misdemeanors, but then we sent them back to South Carolina where they put them in prison because there was a felony provision in there like you're asking for now. So it works really well to have that definition there. Because we were kind of at a loss of what to do with that case. I have lots of dog cases I could go through, but every day or every month we see things like this in our area. Like I said before, I don't think anybody in my particular part of the country wants any animal mistreated, but they also want to know that they can be assured that what they do, as far as hunting and stuff like this, is protected. And I do thank you for that, and the committee.
I thank you, District Attorney Altman, for your testimony. I think the fact that coming from you and really where you're from, because everybody's from somewhere, right?
Yeah, and I was born in the swamp down in Okefenokee, so that's down in the way part of the South Georgia.
Oh, so you've got double credibility.
Double
on
credibility.
Issue, is what you're saying. More than I do, that's for sure. I really appreciate it, because I hope what you're saying reflects the balance which was our intention in this nearly final substitute. So I appreciate it. Any questions for District Attorney Altman?
Thank you for your opportunity to speak.
Thank you, sir, for being here. Let me ask, I know we're on an expedited time basis. Is there anyone in the room who is opposed to the substitute or has any concerns about the substitute at this point? Who would want to be heard? Not necessarily, I'm not saying if anybody's in opposition to it. Or if there are concerns, they're not sure if they're really opposed or not opposed. Won't lock you into it. I see there's a prestigious member of the Department of Agriculture that, on the staff of the Department of Agriculture that's joined us. If you could identify yourself, we'd appreciate it.
Sydney Smith from the Georgia Department of Agriculture. And we reviewed the substitute this morning with Dr. Cobb, the state vet, and we don't have any concerns with this version. Thank you for including us.
Any questions for Ms. Smith, formerly known as Moody?
That's right.
Mr. Chairman, I have a request.
Yes, sir.
If I could, from you suggested you would give me some citations, prosecutors. There you are. Yeah, if I could, not now, but later. I'll get you offline, but I'd like to get those from you. I can do my own list. Even better. Thank you, Mr. Chairman.
I know there were there were one or more animal control officers who were here earlier. If you have the time and inclination, we'd certainly like to hear from you and any opinions you might have, because you're on the front line of this issue. The front line of this issue.
My name is Cindy Wyman. I'm the secretary of the Georgia Animal Control Association, and with me is Nicholas Liddell, who is the District 1 board member to the Georgia Animal Control Association. The Georgia Animal Control Association does support this bill and would like to thank Representative Golick for presenting it. In the past, it has been almost impossible for animal controls to prosecute neglect cases or torture cases. On the felony counts, people can repeatedly beat, burn, do horrendous acts to animals, but as long as there was no part of the body left, as long as there wasn't any visible damage after the fact, there was no case. Long-haired dogs could be repeatedly burned with cigarettes, but when the hair grew back, your case was gone. The other major problem that we've had is starvation cases. Granted, people can forget to feed their dog maybe a day or two, but the cases we see are weeks of repetitive. Again, you find a dog that's skin or bones. As long as the kidneys don't shut down and the dog dies, we have no case. It's been almost 15 years since the animal cruelty statute has been updated in Georgia. In that time, people's perception of how animals should be treated in many areas has greatly changed also. This addressing the different areas of the state and what is considered adequate in those areas, this bill would really help where we can, as animal control officers, respond to the people in our communities as far as what is adequate.
Thank you. Any questions? Seeing none.
Thank you again.
Thank you for taking the time to be here. Is there any other party? I see Mr. Mulcahy. I see Ms. LaBerge. Any comments or questions? Concerns?
We appreciate the work you've done to get through this bill, and it's up to us at Alice, and we do appreciate it. But we don't have any comments on the bill.
Do you have any concerns about the bill?
No, I think we're in good shape on the bill.
Okay. We know it's a delicate balance, and I hope we've demonstrated. Okay. Thank you.
Okay.
Does anyone else like to be heard on it? House Bill 863. Seeing none, we'll adjourn. The full committee will meet again tomorrow afternoon, hopefully on time. Thank you for being here. And we will go, the chair will accept a motion on the bill tomorrow. Thank you.